Welcome to the DFMI Business Lab podcast, brought to you by the Durban Film Art Institute, presented in partnership with DW Academy, supported by the Federal Ministry for Economic Cooperation and Development. DFMI Business Lab podcast draws inspiration from the 18-week online program which focuses on the business elements of filmmaking, aimed at equipping film producers with the skills to grow their careers. Our host today is Hallie Haller, who is an alumni of the DFMI Business Lab.
Welcome to the DFMI Business Lab podcast series, where we explore the business of filmmaking and empower African creatives to build sustainable careers. Today, I'm here with Unathi. My name is Hallie Haller. I'm a film director and a media artist, and I was actually in the DFM Business Lab, so it's really great to be back together with Unathi to talk about these things. And we have a two-part episode here, so this is part 1 of 2, so please check out the second, where we'll be discussing intellectual property and the business of film with Unathi, who is an expert on this subject matter. And Unathi is one of Africa's foremost experts in entertainment law and IP strategy. Unathi's worked extensively with filmmakers, producers, and industry bodies, helping to creatives to transform their ideas into protected, monetizable assets. That's what we all want. Unathi, did I miss anything there?
No, it's fine. It's a bit, it's flattering, but thank you.
Okay, great. And in this first session, we'll really focus on the foundation. So what IP actually means in the context of film, why you should be focusing on it or paying attention to this, even at the very early stages of your career or at the early stages of a project. So the goal is really simple in these 2 episodes, to kind of replace confusion with clarity and fear with empowerment. And I think that really comes across in the modules that Unathi presents with the DFM Business Lab. And that's what we're going to do in these 2 episodes. So let's start at the beginning. Unathi, I think when people think of this subject matter like intellectual property and IP, it feels like something that we can leave for later. I'm curious, do you have any anecdotes or examples about, of filmmakers who really benefited from thinking about this early, or really could have benefited from thinking about this earlier, just to give us some understanding of the world and its players?
Well, I think I have a variety of clients, okay? So I have clients who are aware enough to kind of do their own groundwork, and they bring me in quite early, but they kind of understand what they're doing and they just want me there as support. And then I have clients who may have gone some way into working pre-production kind of work, and then I have to come in and kind of say, okay, so what's going on here? Where are the contracts? Where is this? So they've already gone some ways into some kind of partnership where the details haven't been discussed. Maybe they've worked together as long as 2 years. And now I have to say, okay, well, let's not move forward any further until we clarify some things here. And then, of course, I have clients that have gone as far as actually getting a deal, like a streaming deal or a broadcaster deal, and then there's something wrong with their chain of title. Mm-hmm. So then I either have to go back and fix the chain of title, which most times costs my client more, because you have to go back and it's kind of like you have to offer again, and the person then names whatever price they want. And then, of course, they're just deals that, bad deals that people have done that I can't undo, and they lose everything,
That's so heartbreaking. Yeah.
It is heartbreaking. It is heartbreaking, yeah.
And it's okay, so for a young filmmaker or somebody at the start of a project who's really trying to wrap their heads around this, what is IP and why does it matter?
IP, intellectual property, is the law's way of protecting creativity. So the idea behind the laws of IP, there's a family of laws, of IP laws. So it's copyright, it's trademarks, it's patents, and it's design. Those 4 areas of law together form the IP area, the IP family of IP laws, right? We use copyright the most, but we're not actually limited to using copyright the most. Now, the idea of why these laws even came into being is that you want to reward creativity. You want society to create. So if I was a novelist and I was writing books, but I wasn't getting paid or nobody was buying the books, I wouldn't write the novels. Do you see what I'm saying? I wouldn't write the novels if I wasn't getting some kind of reward. But the issue is, and what most people don't understand, is that reward is in the form of you are the only one allowed to do certain things with that work. Okay? So if the work is a script, you're the only one you're allowed to distribute it for a certain period of time exclusively. You're the only one allowed to do it. You're the only one allowed to make copies of it. You're the only one allowed to do a whole range of activities with it. But after some years, and the copyright laws will say how many years those are, the work has to then go into the public domain for the benefit of society as a whole. And people don't understand that. People think they've got rights forever and a day. And so, they don't understand that it's for a limited duration. So I'm giving you an incentive to continue creating for a limited duration. And that reward, even your heirs can earn from it. So you're kind of creating a kind of generational wealth, okay? And it's all about intangible property. So when you go into a store and you see a car or you buy a pair of shoes, you walk out with it, you can touch it, you can see it. With IP, it's the fruits of the mind. That is what intellectual property is. It's the fruits of the mind. So unlike an apple, if I eat the apple, you want some, you can take a bite of it. With IP, if you eat my apple, if you take my apple, I don't have it anymore. But with IP, I can sing a song, you can sing a song, you haven't deprived me of it. So it's fruits of the mind, and it's protection, and it gives you exclusive incentive and for a period of time.
And I guess also just really incentivizes you to do the work because you're actually building wealth from it, as individual creatives as well.
Yes. But the important thing to remember is that the rights attach to the work. They don't attach to the person.
Explain that a little bit more. Or should we come back?
We can come back to it, yeah.
Okay. So when you are navigating intellectual property, what kinds of intellectual property are the most relevant to filmmaking?
Okay, so we've got copyright. Copyright protects literary works, so scripts. It protects the actual film itself. It protects music that's used in the film. There can be stills that are used to promote the film. It protects all of those. There's certain works and music that can also be used in the film, right? And those works are stipulated in the legislation. Trademark law protects like your production company brand, your production company logo. Anytime you're driving around and you see a big M and it's yellow and red, it's McDonald's. You don't have to be told it's McDonald's. So your brand recognition and equity is really protected by trademark law. And a lot of people, a lot of filmmakers don't explore that area of trademark law. To them, IP is just about intellectual property. And then there's patent law, which protects inventions. Filmmakers don't normally dabble there. But for example, Michael Jackson, who was a musician, did dabble there. And he actually has an invention for shoes, like for moonwalking. So none of this is only exclusive because you only are in music, you can only deal with copyright. You know what I mean? So if you, in the process of making your film, make an invention, you must still go to patent law to protect that.
And
then
when
there's
you
design
say,
law. Sorry.
got you. Sorry,
Yeah.
say that again, the last part.
I was saying, and then there's design law, which protects like textiles and designs and all that kind of thing.
So that's more materials focused.
Materials, but also functional design. So BMW as opposed to Mercedes.
Got you.
The actual design of the car, the design of a toilet. You know what I mean? Like it's a functional design, or it can be an aesthetic design, like textiles. Yeah.
Okay, understood.
Yeah.
And you're saying that filmmakers don't usually work in trademark law. Can you tell me, what do you think is the missed opportunity there, and what should we be paying attention?
You can trademark titles. Tyler Perry, okay. And I guess trademark law, there are fees connected to it. So it's quite expensive to go register a trademark in the trademark registry, because what you have to do is you have to first search the registrars to see if that trademark exists. And there are 42 classes of goods and services. So if it's automobile, or if it's, there are classes of goods and services. So you have to search, and it's quite a hefty price, right? So maybe that's the thing. But Tyler Perry, before he even became famous, he trademarked his own name, and he trademarked character names. I suppose Medea, you know what I mean?
Sure.
So by the time it blew up, it was already protected. So you can trademark your title, your film title. You can trademark your film, your production company name. You can trademark character names, but there are certain requirements that are required under trademark for it to pass a test for whether it can be trademarked or not. So I don't think filmmakers look into that, and I think maybe money is the thing, but it's an investment.
Sure. And so what is the benefit of that? Let's say you like Tyler Perry, trademark a character. What do you get out of that in the long term?
Well, let's think of the benefit. Let's think of Lion King. So
sure.
if I had to try and copy a talking lion and call it Lion King. So it's the merchandising, like a Disney. Disney has built their whole empire on trademarks and trademark protection. Their whole empire. If you think about everything that Disney does. Do you see what I'm saying? So
totally.
The benefit also, before, I'll use another McDonald's example. There was a court case early in my career, I'm not even sure if I was at varsity, where somebody opened a McDonald's here and called it a McDonald's. And McDonald's wasn't trading in South Africa at the time. And the court held, no, McDonald's, you can't stop this person, because you see, it's all about the association of the brand and identifying who's the owner. You know what I mean? So if you're misleading people that you're the rightful owner of McDonald's, trademark's an issue. Do you see what I'm saying?
Yeah. Yes, I do.
Yeah.
Okay. And what about moral rights? How does that fit into the filmmaking practice?
Okay, so moral rights are rights that attach to the author. Okay, so in our business, well, in the IP business, if I'm a creator of a thing, if I write now a poem sitting at my desk, firstly, I've already got automatic copyright protection. The minute it's something new and it's on a piece of paper, I've written it, it's tangible, or even on my computer, it's already got copyright protection. It doesn't need any kind of other registration, okay? The two requirements are originality, and it must be tangible. It must be in a fixed form. If it's a song...
And I imagine you must be able to prove that, right?
Yes. So it must be, you must be able to record the song if it's a song, or you write it down. So that's the first thing. So what was the question again? I forgot. Sorry. Moral rights. Moral rights.
Yeah.
So if I'm the creator, I'm the author, because I'm authoring this poem, right? But now I give the copyright of that poem over to you. I still remain the author. You remain the copyright owner. And so moral rights attach to the author, and IP goes with the work to you as the copyright owner. That's why I said in the beginning, the IP rights, copyright attaches to the work. So wherever the work goes, that's where the copyright goes. But moral rights are personal rights. They attach to the author, and not to the copyright owner, but to the author.
And what does that give you? What do moral rights like present you or protect you from?
3 aspects of moral rights. They mean I have the right to be attributed as the author of that work. I have the right to prevent other people from falsely attributing themselves as the author of that work. And then there's the right of integrity, which means I have the right not to have the work distorted in a manner that that I oppose, or I suppose. So those are the 3 aspects. So often I have to explain to people why those rights are needed. So for example, a producer will ask you to give up your moral rights, right? Because they have to, by the technical editing of the film, they have to distort the film in some way. They have to adapt it, even just to make the film, right? They have to edit it for technical reasons. So they don't want you coming and saying, oh my gosh, you distorted my work, or you showed me in a bad shot, etc. They don't want that. And that's why they ask you to give up the moral rights. But the moral rights really attached to the author and not to the copyright owner.
Okay,
so the copyright owner has rights in the work. If I give you the script or the poem, you then have the copyrights, and you're the rights owner, or you can be the rights holder for that work, and I still remain the author because I created it.
So it's very much about attribution and kind of representing the original intention of the work, I guess.
Yeah, it's about credit. It's
yes,
about credit
absolutely.
also in our field, you know, based on a story by, an adaptation of a story by, you know,
as told
it's about
to, yes.
How is the work presented to the public, and how am I credited for that? Yeah.
Understood. Okay, got you completely.
Good.
I think with
I like it when you understand.
yeah, it's like I'll keep and then film is so complex, and because it requires so much money, who actually owns the film is a really complicated answer. How would you even begin to answer that?
Our law says the default position, unless it's written or changed in a contract, the default position in South Africa is that it is the producer, it is the person who arranges the film. Okay.
So I think something that often happens is you get into collaborations that are operating on goodwill, and there's almost this I don't know, this hesitation to be the first one in some instances to bring up a contract, especially like I think around younger creatives. And what advice would you give just in navigating that situation?
That is what I come across often. People avoiding the conversation, okay, which is the worst thing you can do, because at any point, number one, written agreements are going to be needed if you're planning on getting financing, because no finance is going to go forward with the project when there's no written agreement, okay? So you're going to have to commit at some point, and you're going to have the conversation. Now, it's the type of conversation you're going to have, because you may not even know enough. That's where lawyers are good, because we come in and we know the questions to ask. And we know how to shape that conversation. So we will look at the deal and we'll say, okay, it's this deal. Maybe this is the deal structure. This is how it should go. Are the parties of one mind? And we can come in and negotiate and have that hard conversation on your behalf, because you are going to work with this person. You're still going to have a creative relationship or a business relationship with this person. So
but you need to Okay.
Yeah, so you don't want to be having those aggressive conversations if they need to be. You rather say, let the lawyers talk to each other and then you guys stay out of it. It's cleaner that way, you know? But I'll give you an example of collaborators who never do agreements and who should do agreements. And it's mostly writing teams.
Sure.
Writing teams should, depending, like the head writers or whoever, you know, who your core, the people who are creating together. But that's not to say, which is another wrong assumption, that contribution equals ownership.
Sure. That is a very common wrong assumption.
Yeah, that's not the rule that I'm saying, because people do think that, and wrongly. So,
yes.
Is that I've contributed, so I own. There's a share.
Why is that wrong? Like, how do we debunk that?
I think people, again, need to be educated about IP and need to be aware of their business. You know,
sure.
We're in a business and we also have a responsibility of teaching ourselves everything about the business that we are in. And so that is why DFMI offers the business labs and all the other programs as well, because very rarely do you get this type of information. And now you're already getting it and you're already in your career. It's already late. You know what I mean? The afters should be offering it or earlier on. I am pushing for IP education even at schools, because you must remember, it's not just the creative industries that deal with IP. Every industry deals, it's a business asset. So everybody must know about it, you know? Yeah. So writers, you know, if you have a small writing team and you kind of writing partners, you should actually be having an agreement where you own the work jointly, depending on your contributions, okay? So owning the work jointly, and this is another thing that people don't understand, means you both own 100% of the work together.
Got you.
You own 100% of the work, I own 100% of the work. It's indivisible. It's not 50% you own and I own 50%. We both own the whole. So I cannot do anything I like with the work without your consent.
Right. Got you.
That is what joint authorship means. Yeah. And often I'll hear people say, I own 10% of the work, or I own 25%. It's not possible with IP. It's possible with revenue.
Sure.
You can get 10% of the back end or the profits or whatever. It's possible with revenue. It's not possible in IP. And I see a lot of contracts and even lawyers drafting that way. And it's wrong.
Okay. That's really good to know. So is your advice to just get a contract and get a lawyer to look over it as early in the process as possible?
I would get the lawyer. I would get the lawyer even at negotiation stage.
Okay.
At negotiate to help you. What should I be asking for? This is what it looks like. This is what I want to ask for. You know what I mean? Don't ordinarily, and I mean, people will come to me and say, please draft me a contract. And I'll say, okay, so what are the deal terms? What have you negotiated? And often you would have negotiated 1 or 2 points out of 20.
Sure.
So but you don't know that they're 20 points. I know that they're 20 points. And what you're giving me is 2 points out of the 20. And you're saying, please draft a deal for me.
Exactly.
And in that case, I'll say, no, we have to go back and address this and this and this and this because you haven't addressed it. Yeah.
So why is it? Sorry, go ahead.
Yeah. I'm just saying we know the questions to ask. And even if you're given a contract, you're going to look at what's on the face of the contract, whatever's written on the contract. I'm going to look at what's not in the contract that should be there. You see where people go wrong? Because I drafted the contract, I'm going to leave out everything that kind of favors you, and I'm going to put exactly what I want. Now the contract gets to you and you just look, the other person just looks at what's on the face of it. They
And
don't
not what
know.
they say.
They don't even know what should be in there that's not in there.
Oh, I've been in that exact situation.
I'm so
We
sorry.
learn. We learn. So why is it important to secure rights early in the process?
So that there's no confusion later on.
Mm-hmm.
So that there has to be clarity. Contracts are about creating certainty and clarity. And also, if you don't address them, it might lead to a stalling of the project. It might lead to disputes. You definitely won't find financing while you're in that limbo state. So until the rights are addressed, you're going nowhere, slowly at that. So yeah, it's a difficult conversation to have, but I mean, you got to have it. And often, I do tell people that they shouldn't warehouse their rights, like they shouldn't be so scared to use them that they put them on the shelf,
Sure.
and kind of don't use them because, oh my God, they're so precious. I can't even touch them. I can't let anybody else have them. That doesn't assist you. It doesn't work for you. The rights have to work for you. You know what I mean? And sometimes you give a little here, especially early on in your career, because you've got no leverage. It's like anything else in business. You got to build the reputation. You got to build the leverage. So often early in your career, you make a lot of mistakes, you lose stuff, you learn. But the thing is, as you do more work and get more credibility, then you start building leverage.
And that helps you to, negotiate better terms for yourself going
Absolutely.
forward.
Absolutely. And don't forget, a bad deal is worse than no deal. Because in a bad deal, you can lose not only control, but you can also lose future earnings.
Yes, exactly. Can you elaborate on that for our audience?
No, well, I mean, if you do a deal where you sign away all your IP without understanding what you're doing, if you're making that choice, that's fine. But without understanding what you're doing, you'd rather wait for the good deal. So I often see arrangements where a producer will say to a writer, or a writer's looking for a producer, let's say, right, for their script. Then the producer will say, I'm the copyright owner. You know what I mean? And that writer is looking for a producer because they don't produce. But is it fair that the writer has to give up their script because it's coming from their end, as opposed to a producer who has approached the writer to write for them? Do you see what I'm saying?
Yes, completely.
I see a lot of that kind of exploitation. And in the end, if that writer may still decide to do that, but if that writer doesn't keep a percentage in addition to what they've been paid, but if they don't keep a percentage of their residuals, future earnings from that script, I don't think that's fair. And I know it's a misnomer, but I'm an ethical lawyer. Like, I don't, there's some things that just go against the grain for me. So I'm very, my dealings are ethical. And that's why I say, sometimes if a client has signed an agreement and committed to something, I'm not going to be the one who's going to go in and undo it because you've already signed. Yeah.
Yes.
Yeah.
So what is the easiest way to start? You're in the early negotiation, you haven't got a contract in place, is the absolute first thing to do to get a lawyer, and where do you even look for one?
Okay, where do you look for one? I can recommend. There are very few entertainment lawyers. And when I teach the business lab, I do warn about schemers and dreamers. The people who are in this industry because they think it's glamorous, they think it's sexy, and they're just bottom feeders, who are here to exploit everybody. So there are a lot of lawyers out there who say they do entertainment law and they don't. And then you also get lawyers who are generalist lawyers. You go to them, so they haven't come to you to say, we do entertainment, but you go to them and then they take the work and then they'll bill you for learning the work.
What do you mean?
I mean, if I'm a lawyer and I get a medical case, right? It's got nothing to do with what I know, my field.
Mm-hmm. Oh, I see.
So I need to go and research.
So they're learning on the job and it comes at your expense.
You're learning on the job and I'm going to bill you as the client for that.
Mm-hmm.
Now, is that fair? That's not fair, but that's on you as the client because you went to a lawyer who was not somebody who specializes.
Okay, absolutely.
You see what I'm saying? So you get commercial lawyers, and they're good. They do commercial deals. They may even do huge deals like with the JSC and the banks and law firms and whatever. But do they know production? Do they know how to draft a co-production agreement? Do they know the treaties? Do they know how to draft a production services agreement? Do they know the difference between a production service arrangement
and what to look out for?
and a
Yes,
co-production?
exactly.
Do you see what I'm saying?
Yeah, there's so much contextual knowledge that goes into it.
Yes, absolutely.
And are there any other like really common mistakes that creatives make, I guess?
The first mistake, I think, is not reading your contracts. Contracts. Not paying enough attention to contracts, like whether you're not storing them, like being organized is managing risk. Just that on its own, knowing where your contracts are, continuously updating them. That's managing risk. That's managing a business risk, you know? Then I think often I've seen people lose deals because they didn't clear music, maybe even one song, or they didn't clear something in archive.
Or, so they're just losing distribution or further funding.
They'll lose, I mean, everything, you know? If your chain of title, remember that a chain of title is an unbroken record of your legal, have you cleared everything properly? Or have you acquired the legal rights to everything pertaining to this film? You know? So if there's one link missing, you're not going to get a deal. Unless you go back and fix that link. And so contracts are not paperwork. They are the architecture. They are the backbone of your deal. They are what determines rights, obligations, control, revenue, distribution. You know what I mean? So I don't understand people who don't even read their contracts and they sign because they're going to get a check.
Because it determines the value of your work.
Yeah, they want the NFVF to pay, so they don't even read it. Let's just sign. I mean, you need to know what's in there. You know what I mean? Look, grant agreements are different, you know, but I'm just saying people don't pay enough attention to contracts, and they don't pay enough attention to definition sections. You know, I've seen net profits defined as you'll have 100%. And the filmmakers, and the filmmakers so happy. But when I look at it, it says basically 100% of zero. So
based on definitions,
100% of zero is still zero based on the definition that you've given me here. But you don't see that as a filmmaker, you see. So contracts, I can't learn. Arm yourself with this kind of knowledge. Pay attention. It's okay to make a mistake once or twice in your career as you grow. That's fine. But acquire the knowledge. Become stronger in your IP literacy and your contract language literacy. You know? Yeah, that's that, I think. I'm trying to think of what other mistakes. What other mistakes? Yeah, I would say The uncertainty thing, the vague language, accepting vague language because people don't want to have the difficult conversations, that can get costly. Yeah, I think I had a note somewhere about all the mistakes that people can make, but it's fine. I think we've covered enough.
And then, okay, yes, I think we were pretty thorough.
But lawyers are generally, the more complex your deal is, or the more high stakes. You know, yesterday somebody was asking me, can they go to ChatGPT for a contract? Because I was saying how I feel about using contract templates.
And how is that? How do you feel about that?
About going to ChatGPT?
About using templates.
Oh, wow. Using templates is so dangerous, because every deal is different and you're trying to fit on, I don't know what I can, it's not no deal is, there's no template that can cover every deal.
Totally.
And so people cut and paste. I had one of my clients who gave away all her rights to a researcher without even understanding it because she was cutting and pasting from something. I've seen somebody have to go and have mediation in the US because they took a template off the internet and didn't realize that the jurisdiction would be California. It's costly. It's very, very costly. And so, yeah. Yeah, so I don't agree with the usage of templates. I agree with the usage of a basic structure, like a sponsorship agreement looks like this. You know what I mean? A co-production agreement looks like this. These are the areas that you must cover if you're doing a co-production. But you don't, templates are adapted. They're not, yeah. And same with
you were speaking about ChatGPT, sorry, as a segue into that.
Yeah, so I mean, I like AI. I'm not one of those people who don't want it. I think it's a tool. I don't like it, obviously, to rip. I don't want it to take the actors' jobs, let's say. You know, that's not how much I like it. But I do believe if you're going to pay the actor for the repeated use, then that's okay. You know what I mean? So I don't have a problem if you receive a contract and maybe you want to pass it through ChatGPT to review, like what do I have to watch out for? What is bad here or whatever, that kind of thing. I mean, I think that can help. It doesn't mean though that it's going to give you everything. Do you see what I'm saying? Yeah. So it's a tool.
Okay, got you.
It's not the final, you know. Yeah, sorry.
No worries. You described this world of contracting in films as kind of an architecture because it's chain of title, a series of contracts. What does a basic chain of title look like? What are the parts that make that whole?
Your chain of title are your contracts, okay? Your releases, your script agreements, your option agreements, your cast and crew agreements, your everything that every contributor of the film has brought to the table. Firstly, there should be no work by anybody without you contracting them, which happens a lot, as you know. People are just, you know, they work without contracts. That's already dangerous. So if you're contracting everybody, all those contracts are your chain of title. Because that says to a distributor or a Netflix that I have acquired all these rights in the proper manner, and I've acquired the wrong rights. I've seen people acquire I've acquired the right rights. I've seen people acquire the wrong rights. And then Netflix will say to me, go and fix this, go and get the right rights. Because chain of title controls future earnings, it controls sequels, spin-offs, other rights. You know what I mean? It lives past this project. So you know, your project lives past this particular project, and only your chain of title can secure that for you. Yeah.
Okay, understood completely.
Yeah.
And who usually is compiling the chain of title?
The producer.
Okay.
The producer, sometimes with legal review, like, you know, they'll give it to the lawyer to check. And then there are also legal clearance specialists that can do that for you for a fee, I suppose, you know. Yeah. But and so every contract you are updating, it's a living thing, a chain of title throughout your production. It's a living, you're continuously updating it, you know, and then at whatever stage you are, you give that whole chain to the financier. But if there's one link, and those links, they don't have to be by negligence. They can be orphaned works. An orphan work is where you use a work, but you can't find the owner. You've looked for the owner. No, there's no record of who that owner is. So we call that an orphan work. There can be unexercised options where people don't exercise the option. They can be unsigned documents. Do you know what I mean? Like, so it's not very hard to have a broken link. You know what I mean? So you've got to be pedantic. You've got to make sure everything, and you've got to have, I would say, have a lawyer at least check the rights that are in that they're enough, that they're sufficient. Because otherwise, a streamer like an Amazon will tell you to go back to, just say you're acquiring an option and you haven't acquired the rights for derivative works. Now, derivative works are sequel works. So we do season 1, we want to do season 2, you know, but now I don't have the derivative rights. So Amazon will go say, this rights clause isn't drafted properly. There's no derivative rights here. And then you're going to have to pay again. You're going to have to pay that writer again. So it's better just to do it right the first time. Because once that writer hears that you've got to deal with Amazon, they're not going to be charging their measly 10,000 rands this time.
The first time around, yeah.
They're going to be wanting, you know, I wrote this thing, now you're going to season 2. I think I want 1.1 million. Do you see what I'm saying? So you're always on the back foot.
Got you. I understand completely, and that's why you have to negotiate it in advance. Negotiation is one thing, but I think when you're receiving a grant, those agreements, you know, they're a very different thing to navigate. And how is that different?
Grant agreements are different. Number one, because I think filmmakers think that they don't have any obligations in grant agreements. They think they must just get the money. So they don't really pay attention to their obligations, number one. Number two, some grant agreements, like the NFVF agreement, actually does have a clause about recouping, but they may not enforce. They may not enforce that clause. So, you know, money that is coming from government, filmmakers take that they don't have to pay back. So the pressure is off. It's a bit less pressure. Commercial wise, I mean, if you had to go to the IDC, you go through their whole risk. It's it's onerous, you know, like an IDC process or a private investor process or a financier who's going to give you money versus an NFVF grant that is from government to assist you and to develop the sector. The objective is different. A grant is development. It's developmental in nature. An investor wants commercial return. They want a return on investment. Not that the NFVF and our government doesn't want a return on investment. Now the new minister is saying, where's all this money going? You know, where's the return on investment by government? It is a question he's asking. But a grant agreement is developmental in nature.
Yes. Yeah.
Yeah.
So it's more
So,
about understanding your obligations and what you have
Yeah.
to deliver in order to receive that grant. Yeah.
Yeah.
Mm.
And also, from my point of view, I mean, because I've been in sector leadership as well, so because what happens a lot, or what has happened a lot, is that some producers won't pay their crew or whatever afterwards. So I'm pushing for a blacklist.
Sure.
So if producers do that, then they must not get the next tranche, or they must not be able to apply to the NFA for the next 5 years or 3 years or whatever it is, so that we eradicate this thing. Because if there are no consequences from the actual funder, it's never going to work. You know what I mean?
We're not paying, we're not finishing projects for sure.
Absolutely.
Mhm.
Yeah.
Mhm.
Again, it's for the good of the sector. I can't go to a private investor and kind of, then it's just plain fraud. You know what I mean? Yeah. But
Absolutely.
distributors do that as well. I mean, there are a lot of people who are saying, give me your stuff, I'll distribute it for you, and they're not real distributors. I've had to lodge a matter with was it Interpol? Yeah, like it's gone that far. So yeah, you got to get the international authorities involved sometimes.
Wild. I hope you're making a movie about that.
It hasn't really gone forward. I think for them it's like so small fry, but it's not the
Sure.
point. The point is, if you have criminals operating internationally, it's a concern, and we have to report it. Yeah,
Absolutely.
yeah.
I think
And people take people's scripts as well and do the same thing.
and do the same thing, like say that they're going to produce it, but actually use the material as though they own it. Unathi, I think for me, we've covered such huge ground in this podcast. I'm not sure if is there anything you want to bring up before we kind of close it off?
No, I think I've said enough. I think I've stressed the importance of your contracts, the importance of understanding IP, because you're not just creating, it's a business asset.
Exactly.
And it's something you must monetize for yourself and your heirs. And for us in South Africa, in the position that we're in and the history that we've had, it's a way of generational wealth. And it's also one of the economic levelers. Everybody in the world gets given those 6 rights. You know what I mean? Those 6 rights under copyright, the exclusive right to this, the exclusive right. We all get given it equally. Do you see what I'm saying? If you're a creator.
Sure.
So it really is, it's very democratic in its nature. Do you see what I'm saying? It doesn't distinguish class or race, or it's anybody who's a creator. Yeah. And so we really, and it's an economic right. So we should use it to push ourselves economically.
Yeah, I think the first time that we spoke, or the first time I heard you, give a class in the Durban Film Art Lab, I also remember kind of having the same realization that as much as we're developing creatively, we should be developing in terms of like the finance and legal aspect of ourselves, and even thinking of ourselves as a business and our individual practice that way. And I think that's what I hope comes across in this podcast and in the next episode. So I just want to say, I guess that brings us to the end of part 1 of the DFMI Business Lab podcast series on intellectual property and the business of film with Unathi Malunga. And today we unpack the fundamentals of understanding IP and like all its different forms. We went into chain of title, we went into common mistakes, and just why this is such an important thing to engage with really early. And so I think in the next episode, we'll be building on this. And so please tune in for episode 2 if you're listening to this, so you can understand more about how to build wealth around your creative practice, and the importance of strengthening our industry by, developing these kind of finance and legal skills.
Thank you for having me.
Yeah, thanks for being with us.
Thank you for listening. We hope that you learned something new or that you felt compelled to further interrogate your professional practice. Never miss an episode. Find us wherever you get your podcasts or sign up to filmart.africa for exclusive video content from this episode, where the African film industry unites.